Now I'd like to welcome up Jonathan Armstrong, partner at Putner Southall Law. Jonathan will examine the challenges facing today's security leaders against the backdrop of a shifting legal and regulatory landscape, as well as some practical solutions. Jonathan, please.
Well, thanks very much for that introduction. I'm happy to guide you through my views on personal liability and the changing climate for cybersecurity professionals. I think this is quite a big issue at the moment. I think it's something that not a lot of people are talking about. And of course, whilst it affects those at the top of the ladder, CISOs particularly, CIOs, I think there's also an issue for those of us who are in less senior positions as well. Liability and pinning the blame at people, unfortunately, is an ever present element of data breaches at the moment. And we're seeing individuals be criticized, I think, in some respects, wrongfully for the decisions that they took in the heat of a moment. Now, I've been doing this for 30 years or so. What I would say is that you always have to prepare for incidents in advance. I find it hard that people criticize people who are well prepared and they've taken decisions in the best interests of the organization. So I'm not particularly defending the law as it is here, but what I'm saying is this is the legal regime that we're faced with, and it's important for individuals to look at their personal liability as well as doing the best job they possibly can for the organizations that they work for. So what I'm going to try and do is focus on three of the quite recent cases we've had that have looked at personal liability, try and draw some trends from them, then look at the climate that we're facing generally around personal liability for data breaches, ransomware, and then look at some tips for you if you're about to take a role or considering taking a role, or what your plan should be like if you're in post. So let me start with the Joe Sullivan case. It's one that some of you will be familiar with. Joe Sullivan has spoken at some InfoSec conferences recently. He was the CISO at Uber, but he was also an experienced lawyer. And what happened is effectively there was a ransomware attack on Uber, and Joe Sullivan used a previously pre-authorized bug bounty budget to pay off the people who'd attacked Uber. So effectively, he masked the attack, if you like, through paying a bug bounty. Now, there's credible suggestions that people in the management chain at Uber knew what was happening, but Sullivan was singled out for prosecution by the US DOJ. He was convicted, but the judge took into account his good character, the number of references that were filed from other people in the information security community, and as a result, he was sentenced just to 3 years probation. But the judge was quite scathing and said effectively that even if somebody with the character of Judge Francis comes before the court again, then they can expect a prison term. Now, obviously, cases like Joe Sullivan sent shockwaves through the InfoSec community, and they also made CISOs look at the public statements that they made and their insurance and some of the other aspects of the case that we'll discuss later. But let me bring it back to Europe with a UK case. This is a case of an individual called Carlos Abarca. He was the CIO at TSB Bank PLC. They effectively had a migration project. It was largely to do with a takeover of the bank, and they were severing from their former parent and aligning their IT systems with the acquiring business. This was quite a complicated IT migration program. I actually spoke in the last couple of weeks with somebody who was involved in the project, and they told me, the inside track on what had happened. But the allegation was that Abarca effectively green-lit stages in the project and assured the board that the IT migration project was on track when it wasn't. The suggestion seems to be that at best, some of these gateways should be on amber, perhaps red, certainly not green. There was a supplier failure, again complicated by the fact that this was all connected with the group IT structure, and Abarca was partly held responsible. Now, Abarca said, well, could I really have managed this? This was a complex migration program. And what the regulator said to him is, well, we've looked at your LinkedIn profile. And on your LinkedIn profile, you say that you're experienced in projects like this, you're experienced in change management, and as a result, it is appropriate to fine you. A relatively small fine here, just 81,000 sterling after discount, but a life-changing event for Mr. Barker. The last I heard, he was struggling to find work in financial services, his specialist topic in the EU, and was actually lecturing at a university in Mexico, I believe. And obviously consequential for the employer as well. You'll see some substantial fines against Lloyds because of this incident. So a couple of lessons to be learned from this case, I think. First of all, look at your LinkedIn CV. I know quite a lot of people in this community have been brushing up their LinkedIn profile recently to say that they're specialists in AI. If you're not a specialist in AI, be careful of the wording that you're using, because I think regulators are going to judge you by the statements that you make about your skills. And maybe the second thing to say is that it's not just about the money, in the words of Jessie J. It's also about the long-term reputational damage if you're involved in one of these cases. And even getting acquitted can itself be a failure sometimes, because the internet never forgets, and your role in a particular investigation, if it's not a pleasant association, may be something that potential new positions look at. And then the third one we'll talk about at this stage is the ongoing case against SolarWinds. And again, some of you might have heard Tim Brown speak at events. He's the CISO at SolarWinds. Obviously, a very high-profile attack on SolarWinds, which led to a number of organizations and governments experiencing some issues. He was charged by the SEC, the US regulator, in October 2023. It's important to stress that there's no trial yet. He is, currently not convicted of anything, and some of the charges against him and against SolarWinds were dismissed. But the basic allegation is that SolarWinds overstated its cybersecurity resilience, and it did that through statements that investors could have relied on. And the basis of the allegation is that it was effectively the job of the CISO to look at those statements which were made, which investors could have relied on. And there can obviously be statements on websites, statements on public filings if you act for a business that's subject to listing rules, etc., etc. Now, in concert with the proceedings against SolarWinds, there were also actions against 4 different suppliers who effectively reached settlement with the US authorities last October. And whilst I've focused on these 3 cases, they're not the only ones. We've had other cases like the Birgit Bonnesen case up in Sweden, which involves, in this case, a CEO allegedly misleading the investors in a listed entity about their compliance status. We've had a case involving Thomas Moyer over alleged payments to public officials or giving them a product on trial, and then something of a political case involving, and apologies for my pronunciation, Jin Ziji, which is a similar prosecution in some respects from the Chinese authorities against a Taiwanese individual. And that's perhaps another trend that I'd highlight, that quite often these cases can be somewhat political. I think that we will see, as the political sphere changes, governments of one country looking for scapegoats in another country. And I think those of us who are employed by businesses with an international footprint are perhaps more vulnerable as a result. We just have to watch those politically challenged winds of change at the moment, because I think they have an impact on cases like this as well. So what is the general direction of travel? Well, first of all, I'd point to the legislative changes that we've had in the EU and elsewhere that have tried to up the game as far as cyber resilience is concerned, as far as dealing with data incidents. So obviously, everyone will be familiar with this pace of legislative change. As I've said, I've been doing this for about 30 years. I think the last 18 months have been the greatest pace of change of any year I've seen. You know, when GDPR came in, for example, in 2018, we'd had a relatively long period of some certainty over what GDPR looked like and time to focus on that with just that one significant change. This year, we've been in a completely different environment with NIS2, which obviously affects cybersecurity, DORA, which affects cybersecurity, and of course the UK equivalent in financial services sector, the EU AI Act, some of whose provisions are already in and being used, like the literacy provisions in Article 4, the EU Cyber Resilience Act. I could add the EU Data Act. I could go on in terms of the rapid pace of regulatory change. And that's something that unfortunately all of us have to deal with. But it's also a trend in a lot of that legislation that there's more of a focus on personal responsibility, whether that be people in management positions or leadership positions. The focus is generally there. And of course, in NIS2, that's a sort of piecemeal set of rules. I know that some jurisdictions are not considering bringing in specific person liability. I understand Denmark might be one, for example, but some definitely are. And again, the devil in some respects is going to be in the detail. But even if your home country isn't focused on person liability in NIS2, if you're an organization with international footprint, that won't necessarily protect you if one of the other countries affected by a breach, for example, has person liability in its rules. So as well as legislatures, parliaments, politicians focusing on person liability, prosecutors are as well. I've given you some examples, but we know that there are others where person liability is being looked at. There are also changes to listing rules, for example, in the US with the SEC, and there is a rise in litigation. If we look at pressure groups like NOYB, for example, they have now handled more than 800 cases. Now, they don't all apply, they don't all ask for person liability. In fact, not that many do. They don't all concern cybersecurity. They don't all concern AI, but this is definitely on the agenda for pressure groups, and it's on the agenda for specific groups set up to bring class actions after a data breach. And we've seen the rise of those type of actions around Europe in places like the Netherlands and the UK. And obviously that's an industry in its own right in the US, with big groups of lawyers on both sides concerned with data breach litigation. And we've had examples of a focus on individuals in that litigation in cases involving Yahoo, for example, and SolarWinds. So, having said that it's an issue, how can you protect yourself? How can you cover yourself? Or if you're in a relatively junior position, how can you make your CISO shine in this new environment? Well, I've tried to split this up into some manageable steps to look at pre-employment, that whole the next stage, if you like, and then acceptance of role and what should you do for your initial plan. And I'm going to take some time in the remaining 15 minutes or so to look at those three in turn. So, what would my tips be if you're considering working somewhere? Maybe you've seen a job ad, maybe you've got the call from the headhunter, and you're thinking whether this is the organization for you. Well, first of all, I think you need to do due diligence. And that's going to be a little bit like a company would do due diligence if it was thinking of acquiring another company. And obviously, you can use open source materials to do a lot of that work for you. I think you need to look at prior events. So, have they had incidents in the past? How have they handled them? Has management been criticized? I think you need to look at board composition. Many boards aren't fit for purpose. 30+% of the US's largest corporations don't have somebody who has oversight of AI. The statistics in terms of boards with open positions for directors with cybersecurity expertise is even more acute. So you'll need to look at board composition. Is there somebody on the board who you think has the skills to understand cybersecurity risk? And will they listen to you when you express concerns? And I think it's a double problem if there isn't somebody with those skills. First of all, you might not get budget, you might not get the resources you need, you might not get the board time you need. And secondly, if you end up, if you like, filling the gaps in the board's skills matrix, then and you're the CISO or the CIO, then that makes you more vulnerable if you're the sort of senior expert in the leadership chain. So board composition is very important. I think attitude to compliance is important as well. So, what does the organization say about complying with the relevant standards, and can it back that up with evidence? Systems are likely to be part of this as well. I know I've experienced some data breaches where the fact that the organization had old and antiquated systems was a benefit because none of the main hacking groups either had the skills to hack those systems or had the commercial decision to design exploits for them. But I think that's still very much an issue, and you're going to need to review systems. And obviously, if they're on outdated platforms, that might be an alarm bell. And you'll also need to review the organization's website as well. As I've said, it's it's often the case that outrageous statements are made about security on an organization's website, sometimes on the site itself, sometimes, for example, in the privacy policy, they'll say, we guarantee the safety of your personal data if you input data into our site. Well, that's obviously a guarantee that isn't sustainable. So you'll need to look at the promises that an organization makes on its website as part of your hire or no hire decision. If you've decided that you are interested in the position and you've done your due diligence, then obviously you'll want to look at your contract. And I realize that people who are joining an organization, particularly if they've been headhunted, have more ability to influence that contract than if you're applying for a less senior role and that's a job you really need. But in an ideal world, if you've got the power to contract on your terms, on nearer your terms, I think you'd want to consider the items in this list. First of all, I think the terms of your employment and your job description are fairly critical. Again, a feature of some of these cases, like a Barker, is it perhaps wasn't super certain who was responsible for what. If you can make that clearer in your job description, then I think there's a chance that prosecutors might focus on other people in the organization if they were to blame rather than you. Secondly, you'll want to look at indemnity clauses. Now, I don't want to get too technical legal in the time that we've got, but effectively these are clauses where the company says that it will pay you back, or it will pay damages against you, or it will support you in some other way, typically by providing you with access to good lawyers who will defend you. So you want to look at those sort of clauses in your contract. You'll want to look at your reporting lines and in particular board access. Can you go and speak to members of the board when you think it's necessary? How do those reporting lines work? And obviously, the more gatekeepers there are between you and the board, the less ideal. So ideally, you'd like some ability to speak to the board and senior management directly when you need to. Next, obviously, resources. It's the perennial problem, isn't it, of CISOs. You want the resources to buy the right tools to do the job for you. That might be Qualys tools, it might be someone else's tools, but you need the ability to try and prevent breaches and to respond to them when they happen. You'll also want to look at D&O insurance. So for those of you who are not familiar with it, this is specialist insurance that covers directors and officers in an organization. It won't keep you guaranteed to be out of trouble, and there are very complicated legal reasons as to why D&O insurance isn't the whole answer. But if you can get on the D&O insurance, then you're likely to be more protected. You're likely to be a less attractive target for those civil actions that we've talked about, because anybody suing you will know that you have got a pot of money guaranteed by the insurers to be able to fight back. And then lastly, as far as the contract is concerned, I know this is a bit the opposite of the advice a lot of people are giving you in this situation, but be careful about bonuses and options. One of the underlying worries in some of the cases is that regulators have said this individual stood to gain by covering up the data breach or by saying our security was better than it was. And often that is because they have stock options or they have a bonus that depends on the share price. So whenever we're involved in a data breach that involves a public entity, as lawyers, we always think very hard about who needs to know about this and to check that they're not trading stock. Increasingly, regulators have said that if people are trading in shares or stock in a company when they know something that the market doesn't, like a data breach, which could influence share price, then they may be prosecuted. And I think the same logic potentially applies to bonuses that are tied to share price, to stock options, etc. as well. So watch out how you get paid. If it's a low base plus a higher bonus, then I think that potentially exposes you to greater liability. And I'm not saying turn them down. I'm not saying turn the money down. But what I am saying is understand that the risk might be greater for you in those circumstances. And then, excuse me, assuming you take the role and you get that contract sorted out, what does your 100-day plan look like? What are the sort of things that you'd like to bear in mind there? Well, I think first of all, you'll want to do a gap analysis. That'll be the team, the processes, the technology involved, again, designed to prevent data breaches and enable you to respond when they happen. Secondly, personal view, be wary of audits. I say be wary of audits because I think often people go into a role, commission an audit. If you haven't got the resources to fix stuff, that audit is likely to be requested by litigants if there is an incident, by regulators. And we've seen regulators increasing the penalties when people have commissioned an audit, have been shown that they have issues to address, and they've not fixed them. So audits are great if you're convinced you have the resources to fix everything. My suggestion would be in the first 100 days, you haven't got that assurance. You don't know the resources you've got. You might not know all of the tech. You might not know the skills of the various team members that you've inherited. So be really wary of audits. Even if legal professional privilege is written all over them, they're unlikely to be privileged. And as I've said, in this trend for increasing litigation, we've seen litigants demanding information as part of their structuring of that litigation. So also look out for board briefings, skills, assessments, training for the board. It'll be mandatory in some cases like AI under the EU AI Act, but it's also a good idea to help get resources, help get buy-in from senior management. Look at employee training. Look at a data breach academy. Obviously, we'd be delighted if we did it for you. It doesn't have to be us, but you've got to accurately simulate a data breach. Everybody gets better with practice. It's the same as golf. It's the same with any sport. You need muscle memory, and you've got to rehearse a data breach. And I would say the sooner you do that, the better. Learn from incidents and near misses, and be honest. It shouldn't need saying, but a lot of the cases come from individuals misstating the truth or being over ambitious about the cyber resilience of the organization that they work for. So honesty as a result is key. Now, I know that's been a really quick rattle through in just less than 30 minutes of some of the issues that I've seen and are coming across my desk at the moment. You should be able to see a resources page in front of you, which gives you some materials on some of the issues that I've talked about. If you want to take some time to find out more about this particular area. If you've got any burning questions, I'm happy to take those via email or via socials, and you should have the information in front of you on the screen there. All that remains is really to thank you for listening. I hope that you've understood a bit more about the issues involved and some solutions, and enjoy the rest of the conference. Thank you.